have never had to turn over my communications that I had with an expert witness or anybody for that matters, because it's 100% work product. So in this case, you guys or Alan Jackson or whoever it was had to turn over their communications that they had with some of the ARCCA experts. And to me, again, that just like, whoa, that is like theories. I mean, that could include that, your theories and your opinions and your strategies in the case that you're talking about with the expert, which anyone, and Bob's dealt with experts. You're talking theories the entire time with the expert. We think this happened, maybe that happened. Can you test this? Can you test that? What do you think about this theory? And if the other side gets to see all the theories that you're testing out, I mean, like seems wildly unfair. And I understand that it was kind of a sanction in this case, but it just was, to me, it was just so improper and inappropriate. Like, this guy, give me a fine, fine us. But like the work product which is going to help get my client acquitted, I have to turn that over to the prosecution now. So is this the first time you saw this in Massachusetts, or is this something normal that happens in Massachusetts?
No, definitely the first time I saw it. And I'm going to let Bob handle this question because Bob handled this issue at trial. But the only comment I would make is that, we were accused by supporters of the other side of pushing conspiracy theories and hoaxes. But this was truly the biggest hoax of the whole trial. That's what Bob called it, the ARCA hoax, that, there was something nefarious going on when there was absolutely zero evidence of that. The jury was not allowed to hear it, but we didn't hire ARCA. The federal government did when they looked at this case. ARCA came to all their conclusions well before we ever knew they existed. And essentially, once they were released to us to be able to testify, they didn't vary their opinions. So, my view on it was it doesn't matter what the communications were, even from a substantive standpoint, because obviously it didn't affect anything. But I do agree with you that it was, somewhat shocking that, text messages between a defense witness and a defense attorney would be made public by the judge. So, maybe I said too much, but Bob, why don't you handle the rest?